Okay, a big hello to everyone who's just joined us this morning for this webinar, which is titled Payment Plans and Public Access, Exploring New Opportunities for Barristers. I'll start with just a few words about myself. My name is Yuri Rapoport, and I'm an Australian solicitor with a 20-year track record of being at the cutting edge of evolutionary changes in the legal profession, both in Australia and the United Kingdom. The main focus of my professional activity has been the improvement of lawyer-client relations, aiming to introduce win-win solutions that achieve better revenue and profit performance for lawyers while helping clients gain greater access to justice. I've written many articles on the challenges that face the legal profession, particularly in light of changes in client behaviour through the influence of information technology and consumerism. Throughout the years, I've also found myself at the helm of a number of legal service companies that had made a significant impact on the way lawyers approach the business of their professional activity. My most recent solution for the problem currently facing the legal services market in the UK is a venture called Legal Cost Finance. It was founded in 2013 for the purpose of introducing payment plan solutions to consumers of legal services. It operates under FCA Consumer Credit License and has recently become an official partner of the Bar Council. The structure of today's webinar will consist of me talking about legal cost finance, which will be followed by a short video, and then I'll shift my attention onto the opportunities that stand before public access barristers. Now, please don't wait to the end to ask questions. You can type them in as we go along, and I'll try to cover as many as I can within the allocated time. But in any event, I will definitely reply to each question personally by return email after the webinar is finished if we run out of time. Right, so I'm going to talk to you about what is a crucially important aspect of legal practice, the thing that inspires many of us to get up in the morning and strive towards achieving the best results, the thing that makes us work tirelessly without compromising our standards. I will, of course, be talking about the aspect of money. Joking aside, the fact that getting your bill paid is one of the more tangible measures when putting a value on the quality of your legal services. And the problem here is that the clients are usually happy to accept legal advice and representation, but are not always happy when it comes to paying for it. Now, exacerbating this problem are the recent reforms to legal aid. This has resulted in less funding being available for clients. And to make things even worse, the recent increase in court fees have seen the cost of justice go up. So what we have emerging here effectively is a brave modern world of legal practice. And whether we like it or not, many of us will eventually have no choice but to adapt to the realities of commercial forces. Soon, barristers who practice in public access will need to start thinking more about the consumer mindset as it relates directly to the issue of securing instructions. After all, understanding what your client needs is essential to working with your clients directly. And the road to building a successful public access practice is to ensure you're equipped to remain in competition for new clients as long as possible. To do so, you'll have to start doing what service providers in other consumer-facing areas have done for years in order to better understand their customers. So, for example, let's take other consumer-facing services such as estate agents, motor car dealers, retailers, insurers, and even dentists. You'll note that all of these services are not linked to a form of government funding. And yet, despite this, these services have learned how to thrive. And that's because they all, without exception, have figured out what the public access bar is only now beginning to understand. And it's really very simple. To get your client to pay for expensive items such as a new home, a new car, or even legal services for that matter, you must offer a convenient payment solution. So let's consider for a moment payment solutions such as the common home mortgage, auto finance, the credit card, and even dental plan, a payment solution for the high cost of dental services. Now, all the above solutions are underpinned by consumer credit facilities. And this begs the question, why isn't the legal profession doing the same thing? Why isn't the legal profession relying more on private sector finance? Frankly, I don't know, but to me, it seems very logical and obvious that if you're a barrister who wants to get your fees paid on account or upfront, particularly if it's a large sum, that you would go beyond simply announcing your fees to your clients, that you would realize that making legal services cheaper by removing solicitors from the equation doesn't automatically mean that your services become cheap. In fact, barrister services, even through public access, can still be quite costly, which is why barristers must consider offering clients an affordable payment method. I believe there is a genuine opportunity for barristers to harness the unique selling point of public access in a highly tangible manner that not only lowers the cost of legal services, but makes legal services more accessible to consumers. In fact, projecting 10 years into the future, I'll bet that most public access barristers will be offering finance to clients as a standard part of their legal fee structure. At the moment, however, most barristers feel uncomfortable about venturing beyond strict professional boundaries and discussing payment options with their clients. And that's perfectly okay if they're prepared to accept that the barrister next door, who may be professionally just as good, has enough foresight to offer prospective new clients convenient payment alternatives. The point I'm trying to make is that the days of conservative professionalism in legal practice are coming to an end, and the commercial realities are now dictating the terms and conditions for modern legal practice. If you don't believe me, then simply ask your regulator. The Bar Standards Board has been advocating direct public access for about 10 years now. If anything, that's quite a loud signal for barristers to start actively evolving their practices to meet the realities of modern commercial demands. An essential theme of this evolution is professional survival, and that simply boils down to your ability to generate funds. And guess what? At the end of the day, the more convenience you offer your clients in terms of payment, the more funds you are likely to receive. So let's take a closer look at the issue of providing convenient payment solutions by way of finance to your clients. Now, I need to be very clear here. I'm not talking about litigation funding. Litigation funding is not strictly a financing solution. It's more akin to an investment product, enabling the funder to claim a stake in the outcome of the legal case. Now, investing into legal cases as a means of obtaining funds for clients has so far proven to be highly laborious, with only about 8% of cases, usually high quantum matters, actually attracting the funding. What I'm talking about, in total contrast, is a straight credit solution in the form of a payment plan. Let's take a closer look at how this works in practice. I'd like to cite to you the following example from a case study that I've recently encountered. A client directly approached the Barristers' Chambers via a public access scheme seeking assistance with her claim against the landlord. A senior clerk at Chambers referred the client to an appropriate barrister and arranged an initial consultation. At the initial meeting with the client, the barrister provided a cost estimate of £10,000 to run the client's claim. The meeting ended on an encouraging note, with the client saying that she felt the fee was reasonable and that she would most likely proceed with her claim. Subsequently, the barrister sent the client his engagement terms, seeking an initial payment on account of £5,000, which was to be held in barco. 2 weeks later, the client had not returned the signed engagement terms, nor made any further contact with the clerk or the barrister, a situation with which most of you are no doubt familiar. The clerk decided to call the client, asking whether she was intending to proceed with instructing the barrister, as the barrister was soon to be allocated to another matter. The client's response was non-committal, saying that she needed a bit more time to make a decision, etc., another familiar situation. And in response, the clerk happened to ask the client if she was aware that she could pay her legal costs by small installments over time, instead of paying the $5,000 in advance. The clerk went on to explain how this payment option worked. The clerk emphasized that the client would not need to pay anything from her pocket in advance, and that a third-party financier, in this case legal cost finance, would pay her full $10,000 fee to the barrister on the client's behalf. The client would then repay the £10,000 conveniently by affordable installments over an extended period, for example, 3 years. The client also mentioned that a decision on the client's eligibility for legal cost finance would be made within 24 hours, which is once again distinctly different to litigation funding, which can take months of due diligence. Also, the clerk told the client that no personal security was required to qualify for the specialised payment plan. The only criteria were the client's creditworthiness and the ability to make repayments. Now, it so happened that this client was experiencing cash flow problems at the time. This prevented her from committing to instructing the barrister. However, since she had no previous issues with her credit history, the client saw legal cost finance as an opportune way to commence her claim immediately without having to outlay a substantial amount of money. Moreover, if the client was to win her case, she could repay legal cost finance in full at any time without penalties for early repayment. The clerk provided the client's details to legal cost finance, and within a matter of a couple of days, legal cost finance proceeded to approve £10,000 in favour of the barrister's future fees. Now, incidentally, that particular clerk recommended to all his barristers in his set to amend their engagement terms and include a standard payment plan clause. He felt that the clause would provide barristers with a competitive advantage over other chambers, which would in turn benefit his chamber's revenue-generating abilities. In fact, he was right. 3 months after, he reported to me that a revenue increase of 18% had been seen after implementing payment plans for most of his public access clients. So what this means is that routinely mentioning the option of a payment plan to your prospective clients can be a very effective way to offer your services, as opposed to approaching clients with the mission of procuring a large amount up front. I put it to you that it'll be those barristers who understand and accommodate their clients' needs for convenience and affordability that will survive the current evolutionary changes. And it will be these barristers who will prosper in the brave modern world of legal practice. Now, I think I've said enough about payment plans for the time being, and before moving on to the second part of this seminar, I'd like to take this opportunity to present a video about legal cost finance that we recently put together, which can be a useful way for you to introduce legal cost finance to your clients. A copy of the video will be available on our website shortly for you and your clients to download at your convenience.
Nobody wanted to know me, because I didn't have the funds to pay up front. I told them I had a steady job and that I could pay their fees over time. But all the solicitors and barristers just shut their doors on me.
Not having the money to pay my lawyer made me scared and angry at the same time. I wasn't even angry with him. He just wanted money for doing his job. I was angry with the system.
It's really quite common for clients to feel anxious about legal costs. They want their lawyers to invest in their cause, to believe in the promise of a windfall, and to take the leap of faith together, so to speak. But in reality, lawyers can't always do that. They have financial commitments of their own to take care of. And so the legal services market needs a solution that would see a much broader section of clients being able to afford paying for legal services.
It took me by total surprise. When he said that their firm offered payment plans to clients, I couldn't believe my ears. I even asked him again, "You did say that I could pay your fees by small instalments over an extended period."
I said, "What? How come I've never heard of it before?" After I just spent months convincing 3 different barristers to take my case on a no-win, no-fee basis, thanks to legal cost finance, I suddenly had the power to choose the barrister I wanted.
We set out to transform the legal services market. We wanted to introduce payment plans on a meaningful scale that would enable greater affordability of legal fees at a time when it was most needed. But it's the finance behind the payment plans that plays the most significant role. It provides the necessary funds to cover lawyers' current and future billing, while offering clients the opportunity to repay the credit facility by small instalments over a convenient time period. Overall, legal cost finance helps